Good morning, online people as well. I'll hold that. Okay, so we are going to go into our presentation now. We've got Beta back. We're really excited. You had a big, a lot of people asked about your presentation the last time and liked it and rewatched it. So I'm glad you're back.
Excellent. I'm glad to be
I think it's a little bit of a different topic, but kind of similar.
Yeah, more real estate related, but it's a little bit of sprinkled with some landlord and tenant.
Perfect. We love landlord and tenant stuff. And as you guys know, we do probably about 200 leases a month. And still a lot of agents don't understand a lot of the rules and they make up their own rules. So that's why we've got Beta, your paralegal. So we can ask you questions and you're a good resource for us. So sometimes if we can't answer the question from you guys, sometimes we send you guys over to Beta. So she's going to do a presentation for you guys on Tressa. We love Tressa or Teresa, some people are calling it. Who's Teresa? So we're gonna do a presentation for you guys. If you have any questions, do you want them as you go or at the end?
Hold them to the very end.
Okay, so if you're online, put your questions in the chat box. If you guys are in person, we'll do some questions at the end. But I will let you get started. Actually, yeah, let's check. Remember last time we had the mic? Can you guys hear me online? I know I heard, is there volume yet? But that was early. We can get mic. Okay, we can hear us. Perfect. So I'm going to whip up your presentation. We're just going to use the computer. Last time we tried to do the microphone and that went really well.
I feel like we can do it.
What's that? Okay, perfect. I will let you take it away.
All right. Good morning, everyone. Good morning, and thank you so much for taking time out of your day to come and learn about best legal practices. Here.
You can sit in the chair too if you want.
Want me to stand here? Okay, perfect. Good morning, everyone. Thank you so much for taking time out of your day to come and learn about best legal practices in owning and operating rental property. Today, we're going to talk about mastering Tressa. We all know that Tressa is the new piece of legislation. So we're coming to bring it, we're going to be talking about Tressa and how it will affect your dealings with landlord and tenant related matters when you guys are dealing with landlords and tenants. My name is Bita Delisi. If you already haven't done so, head over to our social media, like us, follow us on Facebook and Instagram. I promise you, you're going to love this type of content. If you also head over to our YouTube channel, lots of great videos there. And as always, if you have a smartphone, you can scan that QR code located at the bottom left of your screen to add us in as an automatic contact to your contact list. And as always, we are here to provide support to you guys, you realtors, and your landlord and investor clients throughout the province of Ontario. So if you ever come across a matter where you require some clarity, perhaps you have a question that can't be answered here, definitely reach out to us. Email is by far the best method of communication with myself because I'm always doing training sessions like this one. But if you do call our office, likely you won't get a hold of me. You will get a hold of a member of my team. There's about 8 of us now, and all of whom will be happy to assist you. So let's get started. There we go. So for the purpose of this presentation, everything we discuss is for information only. Nothing is to be taken as legal advice. If I can kindly ask that you hold your questions to the very end, I promise you we'll open up the floor for a Q&A, and you can ask me anything that's landlord and tenant related. So I'll tell you a bit about who we are and what we do. As mentioned, we provide legal support to realtors and your landlord and investor clients throughout the province of Ontario, mainly in the areas of non-payment of rent, late payment of rent, lots of cash for keys settlements prior to the spring market, owners wanting to occupy their tenanted properties, and new purchasers who purchase tenanted properties and maybe they want to occupy their tenanted properties. There's a photo of our team. There's now 8 of us. So if you call into the office, as mentioned, likely you won't get a hold of me. You may get a member of my team. Again, all of whom will be happy to assist you. So let's talk about TRESA. So what is TRESA? We all know, or we should know what TRESA is. And the Trust in Real Estate Services Act is TRESA. It is the legislative framework governing the real estate industry in Ontario. And it replaces REBA, which many of you veteran agents are familiar with. TRESA sets out the rules and standards for realtors throughout the province of Ontario, ensuring transparency, accountability, and professionalism when you are doing your real estate transactions. So TRESA's main focus is on accountability, professionalism, and basically disclosure, which is what we're going to talk about throughout the presentation as well. The clicker's not working, so I'm just going to...
Yeah, I can use my mouse too.
Oh, perfect.
I'll take the ones. You should be able to, so it's
Just-
yeah, if you click it.
Okay, perfect. So let's talk about how TRESA's influence, how TRESA influences this dynamic. So number one, I mentioned TRESA's main focus is on professional standards. So let's talk about that. Realtors handling tenanted properties must adhere to the TRESA rules. So what are the TRESA rules when it comes to disclosure and professional standards? This includes ensuring landlords and tenants are fully informed about their rights and obligations during a property sale. So when you are acting for, let's say you're on the listing side and you're listing a tenanted property, or you're about to list a tenanted property, it is your responsibility as an agent, because you have that standard of care, to ensure that the seller landlord understands his obligations when he's listing the property for sale and when he's acting to sell as a landlord, because now the seller is wearing two hats: the hat for selling the property and the hat for being a landlord. You also must ensure that the tenant also is aware of their rights. But because agents are not always equipped, or they don't often know how to properly advise the landlord or tenant about their rights, they often guess, or they often assume. And what happens when you assume is you often end up providing the wrong advice, and the client ends up in a little bit of hot water, which is what we're trying to avoid. So before we start off the presentation, you should always be telling your landlord clients to seek legal advice prior to listing a property for sale, so that they know a few things. Number one, what are their options when you receive an agreement of purchase and sale? Number two, does the tenant have to vacate even if the property is sold? And number three, which is very, very important as well, is can you guarantee vacant possession? Okay, which leads me to number two, clearer disclosure requirements, especially for landlords. We know that the Landlord and Tenant Board is very tenant friendly. They're very lenient. So what I mean by that is that if a landlord does something incorrectly, what happens? They get penalized. They get fined. But if a tenant does something incorrectly, what happens? Nothing. So we want, that's right, it happens. So we want to make sure, and more than likely you're representing landlords in this case, landlord seller, we want to make sure that you as a realtor have done your due diligence and have adhered to that standard of care when you're informing your seller, hey seller, this is not just a regular residential property that we're selling. Yes, it's a residential property, it's a residential dwelling, but you're dealing with a tenant. And the law protects the tenant when it comes to providing vacant possession. It doesn't matter if the property is sold firm. It doesn't matter if the property is sold for $20 million. It doesn't matter if the buyer is living in his car and showering at a Tim Hortons. The Landlord and Tenant Board is the only authority that can end a tenancy. And you shouldn't be telling your clients that if a property is sold, don't worry, you're going to get a termination. That's not the case. And we're going to be talking about that throughout the presentation as well. For tenants, I always say for tenants, even though as agents you should also let the tenant know what their obligations are during the sale process. I always tell agents, take a step back. What you should be telling the tenant is to seek legal advice. Always. That way there's a barrier between yourself and the tenant, because at the end of the day, if you're representing the seller landlord, you have to make it clear that you're not playing both sides. Number 3, handling tenanted properties in compliance with the law. So we know that as a professional realtor, you must abide by the trust rules. We know that. We now know that you have to disclose to your landlord client that, hey, landlord, there's an act that you also must play within, and that's the Residential Tenancies Act. So, for example, when you're dealing with tenants, especially when you're dealing with situations where we refer to them as no-fault evictions, where an N12 for the landlord or new purchaser's own use, or an N13 for extensive renovations, converting to non-residential use, or demolition is going to be served. These 2 notices are referred to as no-fault evictions. And what that means is that the eviction is not to the fault of the tenant. It's not the tenant's fault that the landlord wants to move in, or the landlord has sold the property, or the landlord wants to demolish. Even though it's not the tenant's fault, there's still a procedure that must be followed. Remember, you still have to play by the Residential Tenancies Act and the TRESA rules of disclosure and accountability, because more and more applications for bad faith that are flowing through our office, they are listing the realtor. They're listing the brokerage. Now, I don't make very many guarantees, but I can pretty much guarantee that Claire doesn't want any claims landing up on his desk, naming his agents, right? So you don't want to deal with that. That's why we want to play by the rules. Enhanced accountability for realtors. Realtors are now more than ever are more accountable for providing accurate information and accurate advice. And let's talk about that. We had a landlord call us, and this is going back in last January. The landlord said, I have a realtor who listed the property. He went to the tenants. The tenants said, I'm not moving. I'm well equipped with what the law allows me to do. I don't have to move, even though you're wanting to list and sell the property. So the listing agent obtained an offer. It was firm. They pushed me to accept it. See how they're taking off the liability from themselves? The realtor pushed me to accept this offer. So what did I do? I accepted this offer. But the offer was to guarantee vacant possession. There was no direction to serve an N12. There was no direction to obtain an N11. It was just straight offer, firm offer. So I accepted it. And now the tenant is not leaving. So if I close, I'm in breach of the agreement of purchase and sale. The tenant wants an N12. What do I do? Well, the realtor has informed me that if the tenant doesn't leave by the closing date, that I should wait until he vacates the basement apartment. He goes to work, take his belongings, and put them on the front lawn. Can I do that? Oh my goodness, that is it's a good thing you're in the front. Guys, no, you can't do that. That is the worst advice that you can give to your clients. I get it. You want to make a sale, want to make that commission. I totally get it. But we have to play within the rules. In fact, as agents, what you're doing when you give that type of misinformation or the wrong advice, you're putting your license on the line. And for what? For one commission check? Surely your livelihood is worth more than that one commission check. Not only are you putting your license at stake, you're putting the brokerage in a very, very bad position. So that's not what you do, okay? Make sure that if you have a tenanted property and you obtain an agreement of purchase and sale, if you want us to look at the APS and let you know what clauses you need, send me an email. Send me an email, attach the APS. let me look at the APS. Let me tell you what could happen so that you know the risk, so that you can tell your seller landlord what the risk is if you accept this offer as it is. It will save you a lot of trouble. Facilitation of negotiation. So TRESA enables smoother negotiations between buyers and sellers because of the full disclosure. The spotlight is on full disclosure. For landlords, as agents, guys, you can inform your clients that we have a few ways that we can guarantee vacant possession, right? But prior to accepting an offer, there's cash for key strategy that can always be explored, or the N12 strategy, only if the buyer requires possession for their own use. Now, let's talk about for your own use. For your own use means you're physically going to move into the property and use it as your principal residence. Show of hands, we know that you cannot have more than one principal residence. Correct? Okay. It cannot be a place where they can crash over the weekend. It cannot be there, my son is going to stay there a couple nights a week. No. You physically have, just like a first-time buyer. Who's a first-time buyer? First-time buyer is a buyer who's purchasing the property for the first time to physically move in and use it as their principal residence. If a notice is served in bad faith to deceive the tenant to move out, guess who your client is going to hold accountable? Agents. And I promise you, there are RICO disciplinary actions and orders that if you send me an email, the public orders, I can send them to you. You can see what other agents have been fined for doing things out of their scope of work, providing advice or assumptions that the seller follows because they're relying on you as the professional. For tenants, guys, as agents, I always say for tenants, say tenant, obtain your own legal advice. Even though as realtors, you can help ensure that the tenants are fully aware that they do not have to move. But if you're listing the property, why would you do that? Why would you tell the tenant, hey, tenant, you don't have to move, right? You're working for the seller. Make sure that you don't play good cop, bad cop. That will come back and bite you. Preventing unauthorized practices. I had another agent who informed his client, this is in Brampton, that the tenant's not paying rent. Tenant wasn't paying rent. Tenant moved in his parents, and Sanak, close your ears. Realtor told landlord, hey, landlord, don't worry about it. Stake out the place, put the tenant's stuff on the front lawn, change the locks. Police can't do anything. This is the realtor's advice. Police can't do anything. Tenant comes home, his parents, I shouldn't be laughing. His parents and his belongings are on the front lawn. What does he do? What do you do? You call the police. Now, yes, the police cannot get involved with landlord and tenant disputes. However, police also have the duty to keep the peace. If the police are aware that a tenant is on a lease agreement and there is no landlord and tenant board order for eviction, they are allowed to say, hey, tenant, you can go back in. So what happened? That tenant had, now with smartphones, everybody has access to their computer or saved files. He showed the officer the lease. And guess what? Tenant can go back in. So what happened to that realtor? RICO fine. The brokerage got fined. And the broker record actually ended up saying to him that we can no longer have you here. You're too much of a liability. I'm telling you, this is not what you want to risk for your commission. So do not inform your clients to engage in unauthorized practices. So let's talk about how can agents be disciplined if they don't follow TRESA rules. Well, there's a few ways that agents can be disciplined. Number one is always filing a complaint with RICO. I mean, it's very easy. If you go on the RICO website, there's a button that says file a complaint. Anyone can do it. Tenants can do it, landlords can do it, occupants can do it, parents can do it. Any party to a tenancy, it doesn't have to be a landlord and tenant. If they feel that they have been wronged, they can file a complaint. And then what happens? Well, your complaint gets set to an investigator, and it's investigated. The agent is investigated. The brokerage is contacted unnecessarily for giving advice that they shouldn't be giving. Let's talk about types of disciplinary actions. Well, it always comes down to your pocket, right? You can hurt someone by hitting them up for cash. Fines. Agents can be fined up to $50,000 or $100,000 for brokerages. Right? Now, people can only go after damages. But if a tenant knows that they can go after a corporation, especially a real estate brokerage, for free money, what do you think is going to happen? They're going to go after it. They don't care who pays it, as long as somebody pays it. Suspension or revocation of license. I tell you, there are so many RICO orders that have recently come out in 2024 that agent licenses have been suspended or revoked. Send me an email, I'll send you those orders. Agent in Ottawa improperly vetted a tenant and then stopped paying rent, $30,000. Landlord said, why didn't you vet the tenant properly? Claim against the brokerage, claim against the agent. Brokerage let the agent go because they were too much of a liability. You want to be really, really careful. Professional development requirements. Guys, we are all very busy. We know that you have to do your continuing education courses. It's a bit of a pain, I get it, but you don't want to do more. And the reason why is if you're busy selling, you really don't have time to attend courses or do things to satisfy what you're ordered to do. You're too busy. So why not do things properly from the beginning? Public discipline and reprimands. I always say, guard your reputation with your life. If you don't have your reputation, you don't have anything, especially when you're in business. And now with the internet at the tip of everyone's finger, anyone can go online and type in Katelyn Fulton and see everything that comes up. Just an example. So you want to make sure that if the sellers and buyers are doing background searches on agents that they can use, they want to use someone who is credible. They want to use someone who is safe. Administrative orders. These ones are a pain because they're administrative orders, administrative fines. They want you to do such and such and then provide something in writing, confirming completion. I mean, all of this is going to cost you time and money. And sometimes what it's going to cost you is much more than the commission that you made or you ought to have made if you were to do things properly. So you want to stay away from these dealings. Let's talk about examples of realtor misconduct. So I've given examples throughout the presentation, but here are more examples. Misrepresenting tenants' rights. Now, 99% of landlords and agents take the position that the board is tenant friendly, the system is broken, all the rules and the laws are for the tenant. I get it. But at the same time, if you want to achieve a sale, we want to do things properly and not by deceiving or misrepresenting. So claiming tenants must vacate without a proper N12 or N13. So we had an agent who was about to list the property. They went to and spoke to the tenant and they said, hey, tenant, you're going to have to leave anyways. You know, we're going to be selling the property. So it's better that you find another place and you go. That tenant did not want to interfere. They said, no problem. I'll find another place. I'll leave. The coming soon sign was on the lawn. They decided to vacate. And then what happened? The landlord seller said, now that the tenant has vacated, I changed my mind. Take down the sign, realtor. Now I'm going to relist for more money. But an N12 was not served. So the realtor said to the landlord clients, you're in the clear. An N12 was not served, but he was wrong. In the absence of an N12, if it comes to the knowledge of the tenant that, especially from a realtor, that the property is going to be sold, that they have to vacate, even with the absence of an N12, they can bring forward a bad faith application against the landlord. And now the realtor, because the realtor was the one who had that conversation. And not only the landlord, the realtor, but now the brokerage. When it goes to the landlord and tenant board, what happens? In accordance to Section 57 of the Residential Tenancies Act, there is an actual test to bad faith. Number one, did the tenant rely on a notice or information in order to move? Absolutely. Had it not been for the conversation that the realtor had with the tenant, why would the tenant have moved? Why would anyone move, incur costs, pay more in rent just because? Highly unlikely. Is there an advertisement of the rental property? All you need is a photo of that coming soon sign. There's your advertisement. And did the person who was going to move in actually move in? No, because the landlord changed his mind. And I'll tell you, changing your mind is not going to persuade the board, because that way anyone can use the N12 or the N13 as a loophole in order to evict tenants. Number two, failing to disclose tenancies or failing to disclose tenants or occupants that are occupying when you sell a tenanted property, especially if that property is firm, if that offer is firm. We had another agent who listed a tenanted property. And it was fine. The buyer assumed the tenant on the main floor. The buyer thought he was purchasing a detached residential dwelling. He was not aware that there was a secondary tenant in the basement. Remember, TRESA rules, disclose, disclose, disclose. So the offer was firm, closed. Buyer went to the property. He's now the new landlord. He went to introduce himself. And the main floor tenant said, are you going to go to the side entrance and introduce yourself to the basement tenant? Basement tenant. Oh, by the way, who was not paying rent? You have to be really, really careful, because now the buyer's the new landlord. He's acquired this property. One tenant is good and one is not so good. Had he known about the basement tenant who was not paying rent, maybe that would have affected his decision to buy, right? Advising landlords to circumvent the law, suggesting illegal tactics, suggesting that cash for keys be done by the agent. So I'll tell you the story. I had an agent who phoned me, really good friend of mine. He said, Bita, I did your job for you. I'm sitting in the driveway of the rental unit. I got an N11 sign. We all know what an N11 is, right? An agreement to end the tenancy, mutual agreement to end the tenancy. I said, you did? He goes, yes, I did. It was very easy. I gave them $15,000 as certified funds. They signed the N11. And here I am going, oh my goodness, you gave them $15,000 without calling me first? Mm-hmm. Yeah. I said, okay, send me the N11. Let me see what you did. So he took a picture of the N11. He's still sitting in his Mercedes on the driveway of the rental unit. Sends me the N11. I'm looking at it. I said, that's great, but there are two people listed as tenants, but only one signature. Oh, don't worry. Don't worry. If that's all that's left, I will just knock on the door and get the wife to sign. Now, when you give somebody money, I already know what's going to happen. I said, okay, good. Call me back. Goes to the side entrance, knocks on the door. Tenant's husband opens the door and he goes, I'm missing your wife's signature. So the tenant looks at the piece of paper and goes, it's going to cost you another $15,000. Guys, on an $800,000 property, it cost him. Now, that's not the end of the story. What happened? Tenant moved out. Landlord said, well, now that the tenant moved out, I'm going to re-rent it. No problem. An N11 was signed, not an N12. Remember, even in the absence of an N12, even with an N11 signed, the reason why the tenant signed that N11 is why? Because it came to their knowledge that the property was being listed for sale. Tenant made $30,000 just for signing the N11. Now they brought a claim against the landlord, against the realtor, and his brokerage for misrepresentation. So firstly, cash for keys wasn't done properly because that's not the way we do cash for keys. We have terms of settlement. And secondly, as agents, you're jeopardizing your license, especially if you think you know. Inaccurate listing details, omitting material facts, very important information. Leaving out on a listing that the basement unit is tenanted. Leaving out what the rent amount is. You have a duty to disclose what the rents are, because people should be free to make decisions voluntarily and not deceitfully. So what can you do as an agent to avoid making these mistakes? I always say, stay educated and up to date. Great agents stay on top of their game. Great agents are always attending educational sessions like this one. They're always keeping up to date with what's going on so that they can better inform their team, they can better inform their clients. So definitely stay up to date. Stay up to date with any amendments with respect to trust up, if any. We know that it is very new, but any future amendments you should stay on top of. The Residential Tenancies Act, even though the Residential Tenancies Act mostly handles landlord and tenant relations, you will inevitably come across a tenanted property or deal with a landlord seller. So you have to know the basics. Maintain clear and accurate documentation. I always say, guys, as agents, anytime you're dealing with a landlord and tenant, keep a folder and document. On this date, this time, this is what happened. On this date, this time, I attended the property, and this is what happened. I cannot tell you how many times my notes have saved me. I promise you, your notes will save you one day. Keep everything documented. You have to know if any notices of termination, especially no fault notices, were ever served to the tenant prior to listing the property, because you have a duty to disclose. Work within legal boundaries. Now, I know some agents want to work outside of the legal boundaries. I get it. You want to get it done. I understand. But I promise you, there is a way to get it done within the legal boundaries to protect yourselves and to protect the brokerage. That's what we're here for. And I've been saying it throughout the presentation. Avoid playing good cop, bad cop. Make sure the tenant understands that you represent the landlord and seller in the sale of a property. That they should obtain legal advice now or later on, but they know whose side you're on. You can't play both sides. Communicate transparently with all parties. If you're representing the landlord, firstly, you should be telling them, seek legal advice prior to us listing, because you need to know what could happen and what the risk is if the tenant doesn't leave. There's a lot of money on the line, potentially for being sued. So you want to make sure that you understand your rights as a landlord when it comes to the sale of the property. With tenants, you should be explaining their rights. Mainly the right that they don't have to vacate, even if the property is sold firm. But I always say, guys, remember, You have to draw that line. The tenant can obtain their own free independent legal advice from the landlord and tenant board. So even though when trust is involved and trust and transparency is the focus, tenants should also be informed. But remember, you're on the side of the landlord seller. Use standardized forms. Always use the RICO-approved forms. Don't make your own agreements. Don't alter the landlord or tenant board forms. Don't add things. Don't put stars and asterisks on the N11 or on the N12. You're not qualified to alter legal documents. And quite frankly, any end notice or agreement from the landlord and tenant board cannot be altered. So if you are altering them and someone files the signed copies that are altered, it will raise a concern or a red flag at the board. You will not get an eviction order. And verify, verify, verify. Your job is to do your due diligence. There is a duty of care and a standard of care that you owe your clients. So make sure that you're doing your duty of care. Make sure you're doing your due diligence. You're verifying how many tenants are occupying the property. What is the rent? Who's occupying the property? Has there been any missed rents? Does the tenant pay in full and on time? Is there a lease agreement? Remember, when you're listing a tenanted property, these are questions that a buyer agent is going to ask you or should ask you. So you should know all of this in advance. Basic information. And make sure, again, all of this information you're writing down. On this date, this time, I had a conversation with my seller landlord, and they confirmed that this is the rent, this is who's occupying, this is how many tenants are living in the building, whatever the case is. I promise you, your notes will save you one day. Ooh. Avoid making assumptions. This is a big one. Do not assume that the tenant is going to vacate. Do not assume that the tenant will vacate even with a signed N11, because they can always change their mind. And going through the landlord and tenant board is timely. It doesn't happen overnight. Remember, the board doesn't care if you sold your property. They don't care if you sold it for $20 million. They don't care if the buyer is going to be homeless. You have to follow a procedure to go through the board. That's why many landlords, before they list a property for sale, they end up doing cash for keys. They end up doing a settlement. Because once the tenant is gone, you can list without any headaches. There's not going to be any issues with access to the property. There won't be any issues with taking photos or video. Don't come in on this date, this time. I have a sick child. I have COVID. My parents are visiting. It's not convenient. I haven't had time to put the dog in the other room. You're going to avoid all that headache. The biggest thing you're going to avoid is vacant possession, because the tenant already left. Carry errors and omissions insurance. I know this is a basic one, but believe me, it's not so basic. Many agents are practicing without errors and omissions insurance. Remember to read your policy. Oftentimes your policy doesn't contain protection for dealing with landlord and tenant disputes. It may be extra for that to be covered. It may be worth it for you to consider. Develop a checklist for dealing with tenanted properties. Pilots use checklists, right? They do the same thing every day. I use checklists. I do the same thing every day. But you want to make sure we're all busy. You don't miss anything. Develop a checklist. I promise you, your notes will save you. And if you don't have a checklist, I will tell you where to get one. Know when to seek help. Let's put our egos aside. We know that there are many fantastic agents with big egos. Know when to seek help. Know when your client needs help. Don't assume. That's what we're here for. Even if you think it's a stupid question, that small answer could actually save you litigation. Reach out. So we're almost at the end of the presentation. I know it's an overwhelming amount of information, but again, we're here to assist you guys. We're here to provide you with support. If you do have a landlord client who's looking for some legal support, perhaps they're considering cash for keys to sell in the spring, they can actually go to our website, stonegatelegalservices.ca, and book a free consultation right off of the website. Almost at the end of the presentation. Again, I don't charge for any of my giveaways. All these sessions are free. They're very informative. Head over to landlordmastery.ca. You can download your free landlord mastery guide, which gives you access to our Google Drive, and you can download that checklist that I was mentioning right from that drive. You can download the most updated Ontario Standard Lease Agreement with my notes in blue. Lots of great information and resources. How to properly pre-qualify tenants. Everything is on there. You can use it in your business. You can give it away to your clients. Again, it's a great resource. Here we are at the end of the presentation. I would love to open the floor for a Q&A.
If you're selling a property with a tenant, and you actually brought that position, so you deal with one tenant, having representation here. Although that representation is higher than those tenants, they still make an assumption that you're being represented because you represent them. So you're still suggesting strongly that they get advice, and that's for their protection, but also for yours.
Right, but that could be a conflict of interest. As long as it's clear communication that, hey, tenant, I brought you in here, I get it, but I'm now representing the seller. As long as there's no conflict of interest, you may actually want to call RICO and ask them that. Right? That's not really a landlord and tenant thing. That may be a conflict of interest. You may get clarity on that and get that in writing. Okay? You never know what's going to happen. Mm-hmm. This one here. Yes.
I do have a question from someone. It's not really related to your presentation, but it is really to number one on that list. Someone asked if there's a process to process for vetting tenants.
Yes. I think we have that presentation booked. No,
Okay.
that's not the process.
Okay.
That's steps, like questions that you can ask prospective tenants over the phone.
Okay.
But I think we have that presentation booked. Top 10 tools realtors can use to pre-qualify. I think we have that booked. We're going to be talking about the MLS listing for lease, the scope of work for the realtors. Make sure.
You have one book?
I think we have one booked.
Not with it?
Mm.
Oh, okay.
We have 3 books, right?
I don't know, but if not, we will.
Okay. That one's a great
If
one.
not,
Yeah.
that's-
Yeah.
Okay. Do you have like a resource for it online?
I do. It's the qualified tenant
Okay,
prospects.
so I'll
Yeah.
for that.
Yeah.
And otherwise we'll put.
That's a great one. Great one.
When notice N1 is served to the tenant, do they have to acknowledge they got the notice?
No.
Second part of the question is, when you serve the notice, do you need to give any explanation as to why?
The explanation is in the notice.
Sorry?
The explanation for the notice is in the notice. Right? So the N1 is a notice for rent increase.
Right.
Right?
Yeah.
You don't need to write an email. These are the reasons why I'm increasing. No.
Okay,
No,
just
no.
serve the notice and
The less you say, I promise you, is better. Yeah.
thank you.
I have a landlord client who's renting out their home. There's a unit floor unit and the unit floor units had a lot of damage living in the summer. And the water and the sewer bill doubled. In the initial agreement was 60/40 split. But because the main floor units brought so many more people and the utility bill doubled, Aside from having a conversation with people, is there anything that they can do to,
No,
you know?
no. Tenants are allowed to have other roommates, guests, and other people reside. But no. So let me just use that example. Let me give you another example. If these people on the main floor were paying 60%, and let's say the basement was vacant, right? The landlord would have to cough up 40%. Even if these guys were the only ones in the property, but because their lease said 60-40, they're only responsible for 60. Doesn't matter if there's one person, 20 people, doesn't matter.
So even if it was like, yeah, I'm looking to pay something down that people, even though it wasn't explicitly said.
Yeah.
Get this,
Well, how do you calculate another person? What is the formula to calculate? Like you can't.
40% the landlord?
40 is the different.
So what's the basement tenants? Basement tenants, also they're built up.
That's right. That's right. But they have zero position at the board.
Did you see? The basement, if it's not rented or it's vacant.
So I use the same example. I said if I was living on the main floor and I agreed to 60% utilities and the basement tenants had moved out and the bill comes and I'm only responsible for 60. What?
He come and clean the driveway.
And say, hey,
Yeah.
wait a sec. Yeah.
No, let's say the basement is vacant.
I mean, blow, let it blow off all kind of
I
things.
wait in the column after this.
There's no one in the basement office.
Mhm.
Can the landlord use that space or what?
If there's no one in the basement, the landlord can do whatever he wants with the basement.
Even though he doesn't live there. It's upstairs.
The landlord lives upstairs?
No, I mean, not landlord, sorry,
Tenant.
tenant.
Well, the basement is a vacant unit.
Yeah, but it's not finished.
Then it can't be a vacant unit.
It's not.
Okay.
Vacant. And the landlord, is not the landlord, sorry, the tenant upstairs use that space.
I don't know. What's in the lease? Are they renting the whole house or are they renting the main floor? So your leases have to be very clearly, you have to clearly identify the rental unit. So if their use is only the main floor, they would not have access to the basement anyways. Now, if you're giving them access to the basement and it says main floor, that's on the landlord. Right? I think somebody here had a question.
I might have asked this one before, but what if one of our agents puts a tenant into a property, that tenant pays rent, they're a great tenant for, let's say, 2 years, and then they stop paying rent, what is our liability? And
A good question. Very good question. And that was a question that I answered for CBC the National last month. I don't believe that agents are liable for anything that happens after the tenant moves in. Okay, because as agents, you only vet the prospect at the time that the paperwork's given to you based on what's given to you. In fact, when I come back for the vetting prospective tenants, it's not even in the MLS listing for lease what your scope of work is. An agent's scope of work is to list and market. That's it. That's it. That's it. So when does your liability end? That's a good question. Because I don't think that you should be responsible for anything that happens later on. Because anything can happen. It could be a good tenant now. How are you responsible for something that'll happen 2 years down the line? Right? However, there is case law. I was reading one yesterday, and the brokerage, Keller Williams, was there. I'll send it over to you. That the tenant moved in, they started doing damages to the property, they stopped paying the rent, and the agent was sued. Well, how is the agent sued? And it was done in Superior Court. I'll send that to you.
we're in the case right now.
Yeah,
We can do, we can do our own case law, just so you know, you can get sued for anything.
Yes.
Innocent, that's why you have errors, missions insurance. You're talking about extra errors, missions insurance on top of what RICO provides.
well.
Anyway, let's not talk about
Yeah.
that. So we have a situation where somebody, rent their place and 2 years later, they didn't pay rent, so we got a call from the lawyer saying that you put it in the.
Delinquent tenant?
Tenant that consistently doesn't pay rent.
Okay, persistent late.
Predatory tenant.
Okay.
Anyway, so 2 years later, so we're in the lawsuit right now, so I have our own case.
Boy. Well, if there's anything I can help with, let me know. But,
We have another one too,
yeah.
Bounce on that, just to get a lawsuit, just be careful, very clear. We had also rented out a place, somebody thought they were renting out the entire house. And realized it was only the main floor, not the basement, so it wasn't clear on the agreement what the tenant was renting.
Oh, that's a big one. Lots of those happening.
So it's a big problem there. The tenant moved in, thought he was getting the basement, no basement part, just basement. And the landlords wanted the basement for his own stuff, so the landlord wouldn't let the tenant have access to it, so that's.
In the first case, the agent should have notes. Their notes would save them. Hopefully they have notes on what they did to prove qualified.
Yeah, the weird part on the first one there is that they paid the rent for 2 or 3 years, then they stopped. Now we're being sued, so.
Oh,
The variable, I didn't explain, there's a guarantor. type
Yeah.
Situation too, there's one little variable, but.
But
Oh, I
the
see.
problem, we're being accused of putting in this bad tenant. After they paid rent for 3 years.
that doesn't make sense. You already passed the
We're still
limitation.
court as we speak, we're in
Yeah.
court, so next time you
Yeah.
say, where's Claire?
Such a thing, but I didn't know I can sue the person.
But I think it's statute barred.
They didn't know until it's complicated.
A second question is, we have a client that would like us to list his home in Oshawa. And there's a tenant on the main floor, separate room, not separate entrance, not legal in Oshawa. What can they list that on MLS and? What, I know we have to disclose. what
Yeah.
rental is, but it's not a legal rental.
It doesn't have to be legal. I don't know what the brokerage rules are for the legality of listing an illegal property, but the Residential Tenancies Act doesn't say anything that says a unit has to be legal. It just has to be safe.
So disclose the rental amount.
You have to, because of TRESA.
There's a question online. After a bad eviction by landlord and now the tenant is gone, the landlord wants to list for lease again. Do I need to get any docs to make sure nothing unexpected happens with the list?
Can you read that again?
After a bad eviction, by the landlord, the tenant's now gone, but the landlord wants to list property for lease again. Is there any documents for the realtor to have to make sure nothing unexpected happens with the list for when listing?
Well, you can't predict the future, so you don't know. Like there's this one with the 2 years, they've been
Yeah.
paying for 2-3 years, and then you never know what's gonna happen. Anytime a landlord is going to be renting out a property for rental income, they take on non-payment of rent as a risk. It's one of the risks.
I think my answer to that would be, it depends on how they got rid of the tenant. Was the tenant not paying rent and they had to get rid of the not paying rent, or did they give those for that?
Missing some money.
So you're missing
Yeah.
information or what the notice was.
I think there was another,
Regards to what are you seeing roughly for cash for keys agreements, like you're trying to arrange something with the tenant to possibly leave before you list them for sale. Obviously, the 1 month, most landlords know that they did the N12, they'd be obligated to that in addition to the proper notice. So in addition to the 1 month, and I guess there's crazy cases where they're asking 15 plus 15, but on average, is there a number? Is it 2 months, 3 months that you're seeing?
no, it's more figures instead of months. So we generally find that now in and around the $10,000 mark is enticing. And the reason why is because they can put more down somewhere else. It helps with moving costs. And the rent difference can be 6 months to a year. So yeah, around 10 months. 10,000. Anything less than 5, not gonna be excited to move. Yeah. Yeah, inflation, right?
So she won't pay it. I think all the check, but the month after, I boyfriend in India with her. So the landlord called me. No, I want to speak with her. I said, I have to write with you. I have to do it. Boyfriend, so that it was not going to be this. I don't know. Luckily, after a month or so, you get moved out. So assuming if you refuse to move, right, what's the right for the landlord?
Nothing.
No, no laws.
So he can continue to live there without being on the list.
Tenants are allowed to have other occupants, guests, visitors, roommates without the permission of the landlord. The only time the landlord's permission is required is if I say, hey landlord, I want to bring in Katelyn and can you add her as a tenant on the lease? Then the landlord can say, sure, but I need to see her paperwork. So only if we're adding a tenant. But if I'm saying she's my roommate, she's occupying a second bedroom, you have no say.
So I understand even they can just rent one of the rooms, right? Like they keep the money, so they are allowed to do that as well, and landlord cannot do anything.
We have many instances where they rent the second room and then the tenant on the lease vacates and then the roommate is left behind. Now we have to deal with the roommate.
And what's your right?
She's not named person on the lease.
Yeah, so you don't have to be a named person on the lease.
So what's the purpose of signing the lease?
So this is a good question. The lease is kind of like the rules of the game. What is being rented? How much is the rent amount? Who are the occupants? Who are the tenants at the time that the lease is signed? Right? So you can refer back to the lease, but the law trumps the lease. And the law says that the tenant is allowed to have guests, roommates, and other occupants reside with them without the permission of the landlord. It's one of the risks. Remember we talked about risks?
How do you take somebody off the lease? Is it just a mutual agreement between?
So it can be a mutual agreement. So it can be an N11 or it can be an N9 signed by the tenant, the one that is leaving. And then you would just attach that to the lease documents.
And then 11?
An N11, which is an agreement to end the tenancy. So if I agree to let Katelyn off the lease, but yeah, but her sister wants to stay, we'll sign an N11, mutually agreeing to remove her, or she can give me an N9, and then she's off the lease. Right?
I wanted to ask about, I think piggybacking on Harley's question, so when there's a property that has an illegal apartment in it, we need to disclose, but we also don't want to present property so that there's liability to us for suggesting that that could be continued as a tenancy from the realtor side. Yeah, I'm not sure how we got people that.
So you want to make the sale, but you don't want to use ugly terms like illegal basement.
Well,
or illegal
use the
unit.
word legal, but if we acknowledge that there's a main floor tenant and there's a basement. Yeah, you know, but if the property's not a duplex, it's set up.
It's a single family home.
It's a single family home.
Yeah.
Happy to disclose, I guess, the revenue that's there, it is what it is, but at the same time, are we suggesting to a buyer that that process can be continued by having those two parties there? I think it would concern them.
That's up to the buyer. If the buyer wants to assume the tenants, they can do so.
Right, I guess if there was some sort of problem further down the road, and obviously it says that it's there, and it was found that the buyer can continue the process. Maybe we're putting ourselves in jeopardy by saying, yeah, I don't know.
So the act protects the tenancies. Okay, what you're asking me is, does TRESA protect the agents?
Yes.
That's a question for RICO. or for your broker. Right? Some brokerages have rules about
Because I know our
listing.
broker-
I don't want you, so we don't want you listing the legal basis for
Right,
rent.
Right,
right.
So I don't want to see any legal basis not for rent.
Yeah.
If you've got a basement that's not legal, all you can say is the house has 2 kitchens in it. In-law suite, and upstairs rent, that's it. Don't even talk, don't make any representations with the basement tenant or any renters.
Yeah.
but what Vina's saying is that if there is basement apartment income or basement occupant income, then that's not represented, that doesn't.
Well, I wouldn't represent it at all if it's not legal.
But how do you keep the tenant out? Or how this?
Well, if the buyer requires possession, notice can be served. But I think what he's asking is, can we disclose to the buyer that there's a secondary unit and that unit is not legal? And I think the answer is no. You should not put illegal basement apartment. You should put has a secondary kitchen, correct?
Has a secondary kitchen and it's generating 1,200.
Well, that's a question for
Well,
you. That's not me.
Put the retrofit status clause in there too, right? The seller doesn't guarantee retrofit status of the basement apartment.
Yeah, I mean, we use
But on the listing itself, I would just put 2 suites. I wouldn't put what the rental income is on the legal unit.
Can they disclose that?
I wouldn't put it anywhere on the listing.
No, but can it be disclosed?
I would tell a person, well,
Yeah.
by the way, it's a legal basement tenant, they're paying $1,000, but you know, I'm not doing it.
So that's addressing what you suggested earlier, that should be stated, right? So that someone that's seriously buying in, so that they're not caught unaware, oh, there's an apartment, there's an.
But the issue is that the broker rules are you cannot list an illegal unit, correct?
For rent.
For rent. Okay, okay.
So I'm thinking you disclose it to people outside of the MLS that's paying it off. You're disclosing it, but you're not advertising.
Yeah.
It in a public place. That was my, in my.
You're not making any representation that it's
Yeah.
$1,000 rent.
Nothing, right.
Right.
You're not saying that representation.
So you can say it to the cooperating broker over the phone that there is rental
That's
income. I
not-
mean, they can see it when they
That's
go.
not documented. So
Yeah.
is that protection? Is my question.
That's the question for the broker. Yeah, it's,
And most of the
So we'll
basement are
do
legal.
individually each part.
yeah.
Yeah, you show up at a property listing, you find out.
I mean, you can see it's rented.
The clients,
Yeah.
yes, the clients put another occupied. That's your investor client, just for example, and then you find out that there's a second one there.
Yeah.
So then you don't want to put it on as a dual unit listing, right? But you do want to make sure that you're not misleading the buyer. So to speak.
Right, so to adhere to the brokerage rules, I would do exactly what Claire's saying. Say that there's a secondary kitchen. Can you say potential rental income?
No.
No, right?
In-law
Yeah.
suite.
In-law suite.
Everybody knows if there's 2 kitchens, separate
Yeah.
rooms, it's a duck. You know, if it looks like a duck, it looks like a duck, it's a duck.
That's right. So when they're visiting the property, they know a secondary unit.
2 kitchens,
For rental
separate
income.
entrances. I wonder what that is.
It's off topic here, but I don't understand why anybody would have a legal basement today.
Yeah.
Because,
As a broker.
because you have a legal basement apartment, the rental qualifies for qualifying for a mortgage.
Mhm.
And the only reason why it's easy is they want to save time, or they want to save money by guys tradesmen doing under the table or something. I'm trying to save 13%
Mm.
on this, so it doesn't make any sense.
I think somebody else had a question.
Talking about subleasing. I'll be more specific. We rented a apartment for our son in Florida. And in the agreement of lease, it's mentioned that we can sublease it for the 4 months of the year when the university is off. Now, what are the obligations as tenant for us and as a landlord?
Okay, so there must be 4 things at play for a lease, for a sublease to be considered a sublease, okay? So the head tenant, the tenant who's actually on the lease, must have a lease agreement. There must be a 1-year lease agreement and you must be within that term, okay? There must be an end date. Number 2, that head tenant must move out. The person who you're going to be subleasing to must move back, must move in, And then they must move out, the head tenant must move in, all within that 1 year term. That is considered a sublease.
What happens if the subtenant? Rental person doesn't move out on the
Okay, so in that case. In that, no, don't do that. In that case, you're gonna have to bring an application through the board for sublease. You have to explain the facts. It has to go through the board. These type of applications will take 14 months because they're not at the top of the board's priorities to be heard.
Landlord or the initial.
The tenant who is the landlord to the person they're subleasing. Correct. It's a complicated process.
So if the tenant bring a room, okay, and then the tenant leaves after the term or whatever. So then to evict that person because it's a considered guest. Do the landlord should the landlord go to the board or they can just bring the police and say this is a guest?
The police will not evict.
Even for the guest, that is
Even for
not.
the guest. All it takes for the person
he's
staying
not on
behind
a lease.
doesn't matter. Doesn't matter. He's an unauthorized occupant. That's what he is. He's not authorized to be there by the landlord.
Okay.
Right? So the landlord has to file an application. It's actually called the application for unauthorized occupant. File it with the board and go through the board to get this person out. We have many cases like that. And that's because a lot of these roommates cannot find housing. Everything is so expensive.
Like an illegal occupant, right? Because
He's an unauthorized, not illegal, unauthorized. He's legally allowed to be there because the person who was the actual head tenant allowed him to be there. But he's not authorized to be there by the landlord. No, he can stay there until the landlord gets an order to evict. Not indefinitely.
What if the landlord is a tenant himself?
What do you mean?
No, the landlord is not, I mean the tenant is the person who is responsible for the upstairs.
Okay.
The tenant.
Yeah.
They are allowed to do that?
They're allowed to have guests without the permission or roommates. If they leave, the problem arises when that tenant, the head tenant, leaves and they leave them behind. Right? Then the landlord has to pursue an eviction. They can't just change the locks and put their stuff.
Just want to recap what Zero saying here when you're sublease, just so everybody understands. So if you got a tenant that wants to leave, you can correct me if I'm wrong. Tenant wants to leave, and they want to sub that to somebody. You understand that? You understand? And don't plan on coming back. They're gone. That's not a sublease. Just so you know. So if somebody says, "Hey, I'm here. I've got another 6 months left on my lease. I'm going to sublease it to this person. I'm moving back home." That is not a sublease. You have to get a new lease, or you have to assign that lease to that next person.
Yeah.
You follow me there? It's not a sublease. Sublease is only if they're going to be back.
That's right.
Question for you. We have tenants who, for some reason, not tenants, landlords who the tenants don't pay rent, they come to us like 2 months, 3 months, 4 months. What's the recommendation to our landlords when a tenant doesn't pay rent?
Notice immediately. Notice must be served immediately, not 2, 3, 4, 5 months. When tenants fall behind more than 2 months, it's really hard for them to catch up. Because they're spending that money on things that's not housing, on other things.
So the landlord has 15 days in default to start the process?
If rent is due today, the tenant doesn't pay today, the landlord should serve tomorrow.
Everybody got
Right away. Right away.
So if you got an amateur landlord that's housing you says, "Oh, they haven't paid rent for 2 months. What am I going to do in 3 months?" They should have done it paid 1 month, not.
Yes, not 2 months later.
We dealt with such a tenant. After 3 years being very, very good tenant, started being late 5 days, 10 days, 15 days, and then stopped paying. It took us 18 months to get rid
The
of that
pattern,
tenant.
because of the
No
pattern.
payment,
Yeah.
no payment, 18 months.
18 months?
18 months.
If we had a guarantor sign with a tenant, is there any recourse on the guarantor?
I don't like guarantor agreements.
Neither do I. So why do I keep saying that though?
Let me tell you why. So a lease agreement, a fixed term lease is for 1 year, right? A guarantor agreement should have an end date. You can't have an agreement without an end date. Got it?
Okay.
Okay, so if we go on to month 13 and 14, and I say, you know what, I've been really good, but screw it. I'm gonna go buy a pair of shoes. I'm not gonna pay my rent. Well, can you go after the guarantor after 1 year? No, because that has an end date.
Wait, so the guarantor end date ends on that lease, that contract.
It can be argued, when does the because agreements can't be indefinite. There needs to be an end date.
What
When
happens with the month after?
exactly?
So no recourse over there.
Not after the term of the lease, month to month. But if you add the guarantor as a tenant,
Yeah.
occupancy is not a requirement to a tenancy. Right? So unless if I add you as a guarantor, but I say, you know what? No, I don't want to accept guarantor. I'll add you as a tenant. So we're both tenants. And then you don't live there. You're just my brother, you're my tenant, you're my guarantor. And I stop paying. Well, the landlord can list both of us, even though you don't live there. Unless you say after the 12 months, here's my N9. I'm removed from the lease. Be it on or own. Then they can't come after both of us. They can only come after me. But you're right. What happens? Can you pursue a guarantor? And in addition to that, you cannot pursue a guarantor through the landlord and tenant board, because the landlord and tenant board resolves disputes between landlords and tenants. So you have to now go to small claims court on the tort of contract law.
But it
So-
still applies, I can't do it at like a month 13,
Yeah.
14.
You highly likely you won't be successful. Right?
Is the N9 one-sided then?
I'm sorry?
Is the N9 one-sided, so the guarantor or tenant that was?
The N9 is one-sided. So the N9 is a tenant's notice to end the tenancy, right?
What happened when the N9 is served and then the landlord to an agent lease the property to someone else, and then when the time comes for the closing, that the new tenant has to move in, that the tenant who served the N9 is not moving out.
But the roommate is there or they're there?
They just don't want to move out.
They don't want to move. Okay. So remember I said, even with a signed N9 and an N11, the tenant still doesn't have to move out. They can change their mind. That N9 or N11 needs to be filed with the landlord and tenant board. Once filed with the board right away. The board will then issue an eviction order without a hearing. So now you have that in your back pocket. That notice is just a notice. It's as good as toilet paper. It means nothing. It has no enforcement value unless you receive an order from the board. So you file it with the board, you receive an eviction order. So if the tenant does not leave by such and such date, you can enforce an eviction. However, tenants have 10 days from the date that that order was issued to file a motion. And a motion is basically you're asking the courts to do something. And in this case, you're asking them to put a hold or a stay on the eviction for whatever reason. I changed my mind. I don't have a job. I'm sick. I want to finish the school year for my kids, whatever. The board would then, if they grant it, they would put a hold or a stay on the eviction, and then they would hold a hearing, usually 1 or 2 months after. Then the tenant would have to advocate to the board why they believe they shouldn't be evicted. Now, 9 times out of 10, that stay would get lifted and an eviction can follow immediately. But the tenant has the right to be heard. You have two things you're guaranteed, because you're not guaranteed anything else. You have the right to be heard and you have a right to a fair hearing. That's it.
What happened to the person who has signed the lease agreement for that unit and they don't have any other place to go, liable for their responsibility?
Landlord.
Wow.
Landlord. Because you're now in breach of contracts, right? Be very careful.
It's like being a criminal.
So, Mr. Seller here, I recommend you rent the property and you sell it.
That's right.
For filing the N9 with the landlord and tenant board, you do it online or?
We do it online. Everything is online. But make sure that application needs to be filed properly. If there's an error on the application or there's an error in the notice, the board will not issue the eviction order. Will not
when
issue
you
it.
That eviction notice, they send it directly.
All parties,
Oh,
all parties. The board has a duty to notify all parties.
As far as eviction goes, who physically removes the tenant?
Sheriff,
Takes how long to get that done?
I would say 4 to 8 weeks.
So
4 to 8 weeks. We only have 6, believe it or not, 6 sheriffs in, yeah, all of the GTA,
Yeah.
6. Yeah,
Yeah, in that case that I told you, it took us 4 months.
yeah,
It's COVID time and this.
yeah. But other than that, thank you guys. It was a great session. I brought some resources.
We'll have the recording on YouTube. And call Vito when you have tenant problems. Awesome. Thanks online, guys. We
just wanna
will
take a
see
couple
you
of
soon.
pictures with the.
I took a bunch of you too.
Oh, perfect.
Thank you
Can
guys.
I grab one with you and your sister maybe?
Of